One on the first row.
So what? And they want to know what? Oh, yeah, I'm not in charge of that. Yeah, no. Deputy Laura, I'm putting you all in charge of that. We had a discussion about that.
You see the way he treats me?
Yeah, there's something to do there.
I don't think I can.
All right, everyone, I'm going to call the docket. So when I call the docket, please stand, let me know you are here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Today is Tuesday. Monday was a holiday. So this Tuesday is now a Monday and a Tuesday. So everyone, please be patient. In custody, we have Yar. All right, thank you. Jasmine Hardaway. In custody, Angel Gonzalez, Gregory Oliver. And Deputy Laura, Angel Gonzalez is dressed for trial, correct?
Yes.
Thank you. Fidel Ayala. Thank you. Jordan Robbins. Raymond Alejandro. Good morning. Philip Diller. Jesse Garcia, custody. Devin Heflin. Thank you. Devin Heflin, custody. Daniel Hernandez. Deputy Laura, he's not here and I didn't even pronounce the H. And I think I put the accent in the right parts. Matthew Castillo. Alexandra Alvarez. Thank you. In custody, Andrew Orozco. Greg Wright, custody. Caleb Crum. Thank you. Renee Gardia.
Please stand.
In custody is Carlos Terrazas. Joshua Caldwell. Adrian Delaterio, custody. Kent Wells. Jack Lucian Bernal. Arturo Villanueva. Juan Garcia. All right, thank you. Esperanza Bosquez. In custody is Jacob Moya. Rochelle Walker. All right, we'll check. Marcelo Flores. Darius Harris. Ernest Gonzalez.
Present for him, Judge.
All right. In custody is Jamal Price. Jonathan Orozco. All right. Anthony Alves, custody. Gabriella Rubinchuk. Larry Evans. Karen Garnica.
Where are you at? Stand up.
Leon Small. Nicholas Courtney, custody. Jorge Sandoval, custody. Michael Alvarez.
Oyervidas?
Thank you. I didn't know what to do with that Y. Joshua Patillo, custody. All right. Is there anyone who came in late or your name was not called? All right. Sir, what's your name? Do you know your case number or SID number? It should have an NM on the top of your page. One 1827. All right. Do you know who your attorney is? All right. Is that your mom with you? All right, Mom, do you know who his attorney is? All right. Have you had any contact with him? All right. Just remain seated. We're going to make sure you get your attorney contact with him. All right. Anyone else?
Judge, on my client Gonzalez.
No. What's your name, sir? Jacob who?
Yeah.
Leo? Do you know your case number or SID number? Is that your case number? Do you know who your attorney is? I'm sorry, what? All right, just have a seat. Anyone else who's came in late or your name was not called over here? Over here. All right, everyone, these are the rules of the court. And because today is a Monday and a Tuesday, please listen to these rules carefully and please follow them as though your life depended on them, because it does depend on it to make this day an easy day for everyone. So, attorneys, the files for criminal trial division are there. The files for family violence are there. Just grab your file, place your file on the prosecutor's desk, have a seat. They're going to call you in the order of appearance. There's an uptick in COVID, an uptick in flu, an uptick in pneumonia. Knock on wood, I have not had either, and I'm not trying to have either. Even though COVID keeps knocking on the door, I always say, who would you like to speak to? And they say Stephanie Boyd. And you know what I say? She's not here. So let's be kind to everybody and not breathe on each other. If you have a client who's in custody, yes, they need to be called out. Once they're called out, please do not leave the courtroom, because there are only so many people who can be in the box for security reasons. That door, all of the defendants come out of that door. Attorneys, you know that. Please do not block that door. Please do not block the deputy's line of sight. If you block the deputy's line of sight and something goes down and you get ran over, I will happily, but with sadness in my heart, write an affidavit on behalf of the deputy that I instructed you not to block their line of sight. On this side is probation. Probation, could you raise your hand? Do not crowd around her desk. Do not have a seat on the first row if you're in court today. Do not block her. Do not put your items on her desk. Do not sit on her desk. To my left, court reporter. That equipment you see is very expensive. It costs over $10,000. Do not put your paperwork on her desk. Do not lean on her desk. If you damage her equipment, you will have bought it, and you will not leave here till you pay for it. If you have a client who wishes to speak in a language other than English, an interpreter needs to be called, whether you speak their language or not. If you wish to approach the court, you must have conferred with your client and conferred with the state. Once you have done all of those things, approach the clerk. The clerk will pull your file, have a seat. I will call you in the order of appearance. The only exception to that rule is if there's an interpreter who has come down, because there are a limited number of interpreters. Today, we have an intern with us. Please be kind to let him know this is a great profession to be in. because guess what? At some point, we're all going to retire or may need to retire. So he's going to move around the courtroom asking you all questions. Please answer his questions and let him know how great this profession is. All right, we're going to have a jury today. The jurors are going to be up here by 11 o'clock. So move with a purpose. And today is Monday and Tuesday. Please confer with a smile on your face and kindness in your heart. Everyone, please confer.
May I approach Judge?
Yes.
On my client, Ernest Gonzalez, he also has a case in County Court 1. He might be down there.
Okay.
Let me go check on it.
All right. Thank you. Jasmine Hardaway. Daniel Hernandez. Just 1 second. Matthew Castillo. Joshua Caldwell. Esperanza Bosquez. Marcelo Flores. Ernest Gonzalez. Gabriela Rubencheck. Leon Small.
I keep it with him.
All right, thank
I
you.
was getting ready to tell you.
Michael Oberitis. All right, who's with you? All right, you're not on the docket today, so you need to be on another row.
Sure.
And Jay, is your client in custody?
Yeah, they said, what,
They're still involved. Judge is still transporting inmates.
Okay, all right, I'll take your matter up though, because I know, well, we really need him here.
I want to verify 100%.
Okay. All right, and then we'll take that matter up. Thank you.
How long do you think it'd be before they're here? Can I run to County Court 5 real quick?
Yes. All right.
Good morning. How may I help you?
Yeah, it's Rochelle Leanne Walker. Yes, just as soon as she pulls the file for me. All right, if you're coming in and you're late for court and you're on the docket, you need to get on the first row. What is your name?
Page 9, Your Honor.
Thank you. And what's your name? All right, do you have a case number or SID number?
You have a jail card?
All right, just have a seat on the front row and we'll get with you. Rochelle Walker. All right, counsel, if you want to come back a little bit later and see if she's here, otherwise we'll take it up on the docket now.
I called her in the hallway. She didn't answer. She doesn't answer my letters. I have no contact with her.
Okay, we'll take it up. Adriana, can you look to see if this person's on a PR bond or not? It's 2024 CR 0386. It's a PR bond. All right, could I have a prosecutor, please? Court is calling 2024 CR 0386, State of Texas versus Rochelle Leanne Walker. Could I have parties announced for the record for the state?
On Ocho and Nelson.
Defense?
Kenny Callahan not ready.
All right. So this hearing was scheduled at 9 a.m. It is now 9:12 a.m. The defendant has not appeared in the courtroom. In just one moment. Deputy, did you make an announcement for Rochelle Leanne Walker?
Yes, Your Honor, I did. There's no one answer under that name.
All right, defense, have you had contact with your client?
Have written to her but not received response, Your Honor.
All right, and the court notes from the clerk that she's on a PR bond. State?
Your Honor, at this time, we ask that you would issue a warrant for the defendant.
All right, the court will issue a judge's warrant. I'll remain your client without bond. If your client makes an appearance, the court will reconsider.
Yeah, excuse.
Yes, thank you. And are you ready for the people who are here to come up to speak with you?
Just get their information and I'll do that right now.
Vincent Alvarete, come forward, please. All right, the clerk will speak with you. So sometimes people come in and they haven't had contact with their client, but we don't do pre-indicted cases here because it throws off the system. So unless they have an attorney who wants to still have a hearing on the case, we don't have it on pre-indicted cases. So they will check to see if it's pre-indicted. I'd like to check to see if they've had contact with their attorney, because if they have not, I want to try to get the attorney here so they can have contact with them. Yeah. No, it's on the will. The only time I sort of choose an attorney for them, if it's something where I'll call the MAC and say, these are the attorneys in court. Is there an attorney here that you can have to take care of this matter? Because sometimes it's something urgent for the defendant, and I don't like for them to leave the court without an attorney. You're welcome.
What's that?
Oh, and so I requested it.
It's not part of that group.
I don't know.
And then today we're having a jury trial. So some cases may plea out because this is, yes.
Judge, I spoke to him. He's on his way.
All right, thank you. So what ends up happening is some cases may work out, but I give everybody a plea deadline date. So depending on what their plea is, I may accept it if it's good cause to accept it, or I may end up rejecting it, because sometimes you'll have cases where people want to enter a plea, but they just decide, you know what, nothing's happening today. I'm not going to do that. And then they wait till the last minute to do it. And it's the same offer that's been on the table forever. So I'm sorry, just one moment.
You know, it's the one.
Hello? Hi, yep.
I don't know who.
So the one up there, like by the, under the bridge, by the bridge.
All right, thank you.
Let's be different. Okay. Okay, awesome. Thank you. Okay, bye-bye. No, they can renegotiate, but then that really means that it's going to trial. Yeah. Jacob Liao. If you'll come forward, please. All right, and if you'll stand here. And he's saying that he doesn't have an attorney. And then I get this folder every day. And it, oh, yeah, sure. So it's documents for me to sign, decisions for me to make. And sometimes it is motions to revoke are in there. Sometimes it's violation report, and the violation reports are people who are on bond, and maybe they're not reporting to the pretrial services officer or something of that nature. Yes.
We're here at Angel Gonzalez.
Okay.
We're just gonna let you know, we're gonna step out really quickly to other courtrooms unless you need us to be here to confer
Sure.
about anything,
Sure.
or do we have time to run?
Oh, sure. Yes, the jury is going to be up here at 11.
Okay. Then up.
All right, thank you. Oh, usually it's thicker. So I'm sure throughout the day, I'm going to get more things in this folder to sign. I'm sorry, what? No, because you know what? Everything is new. And each case brings something different. That's why I always loved criminal law, because there's always something different every day. On the civil side, you may have a case. For example, if you represent a child, you represent that child until that child becomes of age. So, for example, if you start representing a child and they were 6 months old, you follow them through until they become of age. So, yes, so the file gets pretty thick. And then on the civil side, there is a lot of filings that go on. So it happens. This will be my second term. Yeah. Yes. And elections are about to come up because this seat is up in 2026. Yes. And the primary too. So. Just one moment. Could you mute us for 1 second? Hello? Yes,
This is on Miss Montoya from last week. You told me to come back to see you Tuesday, brought you that letter where she's working full time.
yes.
She's, and you give her 30-day sanction. I'm asking for GPS with permission to work.
Okay, just give me one moment. Raymond Alejandro? All right. So we are scheduled for jury trial. I think the first case up is going to be the murder case. So you all come back at 11?
11 o'clock?
Yes.
And just, understand, we'll be here at 11, just so the clerk knows. I have a federal sentencing tomorrow at 10.
Okay.
Normally it wouldn't be an issue, but the government has told me the amount of people that may come to court that want to speak is 60 to 100 people.
All right.
So look for it now.
Okay, thank
We'll be
you.
back at 11. Thanks, Judge.
Juan Garcia. Good morning.
So my client is in federal custody.
Yes.
Just want to let you know that. He has two cases. He was just sentenced in the Western District over in Del Rio. He has probably about another 3.5 years to do. He's already conferred with the state
Okay.
regarding that matter, and they're going to.
We're gonna reach out to the complainants in our cases and see if there's a resolution that we can do right now while he's still in custody.
Okay. All right. Let's recall this for March 26th. Is that a good date for everyone?
That should work, Judge.
Yes, Your Honor.
All right, we'll come back on March 26th then.
Thank you, Your Honor. May I be
Thank you.
excused?
Yes.
Thank you.
Hello.
Judge, you had told me that, yeah, and I looked at the docket, I didn't see anyone that was.
Oh,
still
it's a
under-
pre-indictment. It's George Martinez. George Martinez, this is your attorney, and he'll speak with you, okay?
Judge, assuming that everything is okay afterwards, and he doesn't want to sort of.
Oh, you're
free
free.
to go or. Okay.
Yes.
Okay, thank you.
Jamal Price.
Ray Lopez, Your Honor, for him, he's in custody right now.
All right, Mr. Price, if you'll come down, please. All right. Hello, Mr. Price. All right. So what is happening with this case?
Judge, we're asking for either a reset or transfer this case to the 290th. We believe he's got a assault family violence second, which is, he's already pled on, and they're waiting a sentencing hearing for April the 3rd. So we just ask them to either reset this case until after that, so we can find out what's going on with the
And which court is it in?
290th.
All right, could you look that up and see if he has a case out of the 290?
He does, Judge, I did look it up prior to you getting the folder, sir.
All right, so your case will be transferred to the 290. All right, is there anything else?
Are we excused, Judge?
Yes, you're excused.
Thank you.
Just have a signature.
And what is the cause number out of the, I see it here. State on Jamal Price, you're aware of the fact that he entered a plea on a case out of 290th. That's an assault, family choking, strangulation, and this is possession less than a gram?
That's the thought in that.
Okay. All right, thank you.
Thank you, Judge.
So for example, this is a second violation report. Since it's second, that means that there was a first. So what I'm gonna do is I'm gonna set this for a hearing. And what's gonna end up happening is we're gonna find out if the first violation report was also for them being out of their area. And we'll take that matter up. So I'm gonna set this one, having to do an emergency setting on it. All right, and on your case, if you will come back, or either I'll call you and let you know my decision. All right, thank you.
All right, thank you. I gave you, I think I gave you.
Yes. All right, thank you so much.
Thank you.
No, I.
Family violence. I don't know if the complainant needs to know of that situation.
Go, take your signals, go away.
Now, this is a violation report. And all of these are violation reports on drug cases. So in these cases, the reason why they have not been indicted is because the laboratory reports are not back. So as far as issuing a warrant for this person for not showing up to pretrial services, it really is unfair because the fact that they're charging him with possession less than a gram, and they don't even have the labs back to say that these are actual drugs, that's an issue. So I'm going to give him 7 days to comply and let his defense attorney know that this person has not contacted pretrial services. So hopefully they will contact pretrial services. Yeah, it does. And on this one, actually, I'm going to see if we can set a hearing. Because I say previously I've given him a chance to comply. And also, here it says that this person has mental health issues, so that may be another reason why he's not complying. So we'll set it for a hearing and see if we can get him back in compliance. Well, it really depends. It depends on the nature of the charges. It depends on whether or not I try to get them in compliance by having them come in. Because a lot of times they'll come in and I will Zoom their pretrial services officer in, so they'll know who their pretrial services officer is and they can report. No, there are others. Yeah. No, thank you. No, actually I didn't. They started it during COVID, but my whole thing is I think that the legal system and the legal process, with exceptions, should be open to the public. Now, if it's involving juveniles, for example, on the juvenile side, I don't think so. If it's involving child protective services cases, I don't think so. But this process, I think that people need to know exactly what happens in their court, exactly how cases are resolved, because sometimes there's a lot of misinformation and I don't like that. So, and then it's to educate the public.
May I approach
Yes.
this off docket?
Sure.
This was the gentleman that we sentenced last week. This is
Mhm.
the expert, DNA expert.
Okay.
That was, and I didn't know if I needed to get a lot of signature, but I thought I better to the world.
Oh, sure. Oh, yeah. No, I heard that. I'm so sorry.
You know, so, but thank you for your.
All right, sure. Oh, excuse me, just 1 second. Hello? Yes, so there's a hot box. You already go out there anytime. It's a lower house. Oh, yes, I'm fine with it, and actually protection. All right, thank you so much, Ryan. Okay, just give me 1 second. All right, yes. No, well, so the criminal laws are the same no matter what court you're in. But I will tell you, when you're first out of law school, you know the law better than any attorney, right? Because you just learned everything and you learned all the new things. As attorneys, we're constantly keeping up. Every day there's a new, not every day, but the legislative update comes out where they've changed laws or changed the range of punishment on something. So that we're learning. And students who are in law school, they already receive that because it happened while they're in school. So that's why I always tell brand new attorneys, do not be timid, because you know sometimes more of the law than we did. So go in, you know, having some confidence, but a lot of it is having experience, really. And the reason why I say that is because there are some cases that come before me where if you've never done criminal cases, you would be, oh my gosh, you know, what should happen in this case? For example, sometimes everybody thinks that everybody who's charged with a DWI and it's a DWI third, they should go to prison. But people don't understand the range of a normal DWI third. The range of time for that is anywhere from 2 to 10 years in prison. Now, mind you, nobody's going to sign a plea bargain agreement unless there's some sort of other issue. Normally, nobody's going to sign a plea bargain agreement where they receive 10 years prison for DWI. And guess what? When that person comes out of prison from that DWI, yes, have them up here at 11:75. Yes, thank you. They're gonna go to prison, and when they go to prison, they're gonna get out. Sometimes people think that someone is charged with a crime, they committed a crime. Oh, send them to prison, they're gonna be prison forever. Now, there are some cases where you look at the facts and you say to yourself, yeah, this person deserves to go to prison. But there are some cases where you say, okay, this person has a mental health issue, this person has a drug issue. Let me see if we can solve the issues and protect the public. And so a lot of times with DWI third, sometimes I'll send people to inpatient treatment. Sometimes I'll send them to felony drug court, because guess what? When they are released from prison, and if they complete, their time on parole, then they can do whatever. At least with this, there's some sort of supervision to make sure that they're remaining clean and sober. So, yeah.
Okay, so that was dismissed and then it was sent down to the misdemeanor and it will be refiled there.
Yeah, what ends up happening, everything is on a case-by-case basis. Sometimes people have a relapse. My role, I think, part of it is not just, oh, bam, you had a relapse, let's send you to prison for 10 years. It's more of, why did you have this relapse? What's going on? Will you get your life in order? If not, then maybe you just want to go to prison. Because sometimes I'll ask people, do you want treatment or you want to go to prison? A lot of times people choose prison because it's easier. Yes.
If you don't get your life in order, you'll look like this.
Yes.
I just wanted to make sure my client was free to go as well.
Yes.
I'd asked about me, but I don't want them to end up. in
No, he
jail.
is. Just tell him to call his bondsman.
Oh,
Yeah.
Well, frankly, we had a nice talk, nice young man.
All right, thank you. So yeah, that's pretty much the way it goes. Jesse Garcia. Hello.
Hello, Judge Boyd.
Hello. All right, you scheduled for jury trial.
Yes.
I was.
So we'll be here at 11.
Great.
All right,
Oh,
thank you.
Thank you so much.
You're welcome. Thank you. Sure. Hello.
Put him on for on that one for a second with the state, but
Okay.
I mean, I'm ready, but the state's probably not.
All right, if you'll confer.
Absolutely, yeah, thank you.
Yeah, so let me finish this violation report just a second.
It's kind of far for the court.
Oliver?
You don't have a docket sheet.
I do, but if it's in there, can you get up to you?
You might be able to find it. Twenty-four, 0165.
Judge Mr. Yadi Yadi can.
All right, just give me one moment and I'll take that up.
Alexandria. Yes.
Well.
And can I see the file on Yar, please? Yes, if you come up, Yar, if you come up, please. Okay, on this case, your client entered a plea,
Yes,
and now the PSI report says he's not a citizen. Is that correct?
yes, Your Honor. I talked to him. He says that he did get his citizenship about a year ago, but I don't have any verification. And the probation office never got a call back. I want to protect his interest, maybe reset this for a week. I'll try to get a hold of his child's mother to see if they could take a picture of it or get a hold of MAC, where maybe there's some way MAC with their immigration experience could check and verify that this is true. I
All
mean,
right, do you have a copy of your citizenship papers?
Yes,
All right, who would have a copy of it?
it's in the house with my bag, my baby mama was with,
You mean the mother of your child?
yes.
All right, so what we'll do is we'll reset this and we'll reset it for March 18th.
Okay. If I can get it prior to that, can I come to the
Yes,
court?
just come back and let us know. We'll put it on the docket earlier.
All right, Judge.
All right, thank you.
If I'll try to get it, okay, and then get you back here. All right, I will. Thank you, Judge.
You're welcome.
Excuse me.
Alexandria Alvarez?
Yes, Your Honor.
Yes, if you all will come forward. So on this case, you're on this side, counsel. So in this case, there was waiting for labs on the 4,200 gram case?
We got the labs back.
Okay,
Judge, just so you're aware, I believe there's a different defense attorney on that case.
all right, who's the attorney on that?
All right.
Okay,
And it doesn't look like that case has been set since I think January 24th.
since when?
January 24th, so it's been a while. There's no other setting that's.
All right, what's the cause number in that case? Because it doesn't show that it's indicted.
It's not indicted yet.
It's an effect.
Ah, so that's why we don't have a setting on that case here.
Can I address the court?
Yes.
Judge, I have conferred, they've given us an offer. I would like to have one reset so she can consider her future. She currently is in a rehab program at Haven for Hope.
All right, so, but the problem is the 4,200 gram case, that's a second degree felony. So, yes,
And Judge, this is where the drug lab shows it's going to be.
1 to 4. All right,
Judge, we could reset this case and then set the nightmare case on the same day
No, that's what I'm doing, counsel, but I'm trying to figure out where we are on that case
Yeah.
because me setting it does no good if we're not where we need to be.
Hey, Judge, it's Nightmare.
Okay, yes.
728.
Mhm.
69.
All right. So then what we're gonna do is we're gonna call this back. And are you in inpatient treatment?
Yes, ma'am.
All right. Is there someone who brings you here?
Pre-trial.
Okay. Are they here today?
They will be once I call them and tell them that I'm done.
Okay.
Yeah, they just dropped me off.
Here today.
Yeah, my mother is here
Her mother
today.
and grandmother. are here.
All right. So is there an issue with them bringing you over or no? You just have to give them notice?
Yes, ma'am.
All right. So what I'm going to do is I'm going to recall this then for March 18th. And we'll have the other attorney here as well. Could I have a reset form, please?
Thank you, Judge.
You're welcome.
Thank you.
And if y'all are able to get here sooner, then we can do it sooner. Thank you. And so do you have the contact information for your other attorney?
No, ma'am.
All right, we're going to make sure that you have that before you leave.
Okay, cool. Thank you.
Adriana,
Yes, ma'am.
could you look up the attorney on NIMAC number 728-693?
728.
693. And if you can give the defendant his information,
Um,
and we'll set all of this at the same time.
And what was the question regarding this case?
What is the attorney's name on that case?
March.
It says two.
And if we can get a phone number for her.
It says two. I saw this before. That says two.
Yeah.
Two what? 20?
I think it's a 6.
That's the 186. That's this, I'm looking at the two setting. Oh, we just didn't count the three.
Mhm.
I'll look it up.
Yes.
That's the attorney's name.
And that's the reset form. Thank you. All right, who's here? Matthew Castillo? Keep up the good work, okay?
Thank you.
Matthew Castillo. All right, why were you late for court?
I had something, multi-tool on my.
I'm sorry, what?
I had a multi-tool on my keychain given to me by my brother and I couldn't throw it away. And the line was to the street.
I'm sorry, I'm not hearing.
Judge, he had a tool that they wouldn't let him bring into the courthouse,
Okay,
so he had to return it to the vehicle and then get back in line.
all right, yeah, you're not allowed to bring those items in, you understand? All right, today is your plea deadline date.
Not a agreement, Judge, we'd like to stay in line for trial.
Okay. How long do you expect this trial to last?
3 days, Judge.
All right, so your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Do you understand?
Judge, can we address one other thing while we're
Yes.
here? Mr. Castillo's been on the monitor for quite a while. He is on a curfew. Problem is the job he works, sometimes goes past the curfew time, but he has to tell the boss, I gotta go home. And the boss is like.
No, I mean, he can work.
So if we could either extend the time or put him on tracking, they let him leave at 7 in the morning, but he's gotta be home by 10. He works in a restaurant, right? And so washing dishes and doing all that sort of thing goes past 10 o'clock.
State, are you objecting to him being on just tracking?
No objection, state.
All right, so if you'll have the B page printed out, we'll take care of that.
Thank you, Judge.
All right, so state, before you leave. So this is going to be set for jury trial in March. What is your settings? Do you know when you're up in March? All right, so you all are next week, the 26th, right?
Yes, ma'am.
So then they'll put the family violence on the 4th, then you all will be on the 11th, but we have a trial set for that day. I think you all will maybe,
My understanding also, judges, people would want that, if that's all we, I know we have a ton of cases that are sent that week. So I think that's kind of what I'm trying.
yeah, okay.
This would be the week of the 4th, the week of the 18th, and then April 1st, at least is what I have.
All right. So I'll put you down for April 2nd and we'll see where we are. And I'll give you a reset form, and once I give you the reset form, you will be excused. All right, once you sign the reset form, you're excused. Thank you.
Thank you. I appreciate it.
Larry Evans. Where's the attorney for Larry Evans?
Here.
Oh, thank you.
I didn't go far, I promise.
All right, let me just find you on the docket sheet.
Could be an add-on, Judge. So a motion to amend the conditions of bond.
Is there going to be an agreement or no?
No.
All right. And this is the motion in both cases?
Affirmative.
Diane, are you ready? All right, the court is calling 2024 CR 0059 and 2024 CR 0056, State of Texas versus Larry Evans. Can I have parties announced for the record for the state?
Anna Ochoa Nelson.
Defense?
Andrew Fraley for Mr. Evans.
And are you Mr. Evans?
Yes, ma'am.
All right, in each of the cause numbers, the court has received a motion to amend bond conditions. State, have you had a chance to review the motions?
Yes, sir.
State, are you prepared to proceed?
Yes, sir.
So it appears that his conditions are GPS full house arrest and no contact with the complainant. And is the complainant the same in each cause number?
To answer your question, yes, Your Honor.
All right,
If I may, I believe he's on partial house arrest at this time, Judge. He's allowed to go from
It's tracking.
his tracking.
okay, well, I'm just saying, because that's what it says in your motion.
What date was that motion filed, Your Honor?
This is November. Do you have an updated one? All right, if you could give me a copy of the updated one.
And Judge, it was modified in January.
All right, thank you.
I'm gonna hand you. Motions.
All right, thank you. I appreciate that.
Those should be file stamped on February the 6th, the
Yes.
last court date. We also have included motions for speedy trial in both cases.
All right,
Assertion of the right to a speedy trial.
all right. So first things first. So there's a partial GPS for work only, and there's no contact with the complainant.
Correct.
So defense, what are you requesting?
We're requesting the removal of the GPS altogether, Your Honor. My client works at Specs as a delivery driver. And it's impossible for him to go all around. Well, excuse me, not possible. He did work that route. Mr. Evans, would you like to explain better than me?
Yes.
Oh, you want to raise your right hand? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Larry Evans,
All right,
Mr. Evans, where do you work?
Specs.
What do you do at Specs?
I deliver liquor.
So when you deliver that, you go all around the city, correct?
Yes.
And when you do that, you originally had a problem
Yeah.
with, when you originally doing it with GPS tracking.
Yes.
And then what happened?
I was with some clients and it went off. And so my supervisor said, since it went off, I can't work the route until I can get it removed. And that takes 2 hours from my
Hold on.
10-hour day.
So he said you can't work the route until you get it removed.
Yeah,
So they shifted you to a different
it's a
position
warehouse.
and you actually lost money based on that.
Yes,
And every day you're losing money based on that information.
yes.
And you could, I don't know if the court wants more explanation on how he's losing money, but with those 2 hours,
Well, I
but
want an explanation on how the fact that he's allowed to work on GPS and it went off and therefore he can't work the route. I don't understand.
do you want to explain?
Well, they said I embarrassed the clients.
Ah, okay.
So they moved him to a position in the warehouse. We would ask that that be removed so he can go back to his original position. I apologize. I'm getting the feedback on the microphone, so it sounds like I'm loud. So Mr. Evans would ask that you remove the GPS tracking. He understands the bond conditions. He understands he needs to stay away from Miss Whitaker. However, with him losing money based on this GPS tracking and the rest of it, that's why we'd ask those to be removed at this time.
All right, State, do you have any questions?
Mr. Evans, have you had any contact with the complainant in these cases?
No more.
Have you had any contact with the family members of the complainants in these cases?
No, ma'am.
Do you, if GPS is removed, do you have any intention of contacting them in these cases?
No, ma'am.
What about the family members of the complainants?
No, ma'am.
No police questions.
All right, any other witnesses?
No, Your Honor.
All right, the court will hear argument.
Judge, he's losing money. There's no argument from the state that he has had, or has he continued to influence anyone in this case? There's no evidence that he has violated the bond conditions before this, and he has no intention of doing so after this. We are asking for a speedy trial as well for that reason.
Well, no,
All-
let's focus on the motion to amend the bond conditions, then we'll get to your speedy trial.
I understand that, Judge, but they go together insofar as that we're asking for this to go forward quickly. We're asking for this to be resolved quickly.
State, are you prepared to go to trial on this today?
Your Honor, yes.
All right, so there we go. We have your speedy trial today.
Okay, so we'd ask for the bond conditions to be removed today as well. Go ahead.
Your Honor, obviously the state will defer to the court. However, it is concerning to the state that we have an incident of June, from the end of June last year. And then we again have an incident from October 22nd of last year. That's a violation of the bond condition to have no contact with the complainant. Now, we did have the opportunity to speak with the complainant a couple of weeks ago. She did confirm that she had not been bothered by the defendant in this case since that October incident. However, we did not have the opportunity to discuss removal of a GPS with her, so we did not have her input on that, Your Honor. But the state does have concerns for that violation of the bond condition initially.
All right, and counsel, I do have concerns as well because there are two cases.
Right,
And the case from, that's ended in 0056, when is that alleged to have occurred?
0056 is the violation of protective order.
Yes.
0056, Your Honor, is the assault family second. That was an offense date of June 25th of 2023. The violation of protective order or bond condition, excuse me, is 0059 with an alleged offense date of October 22nd, 2023.
All right, so I'm not inclined to remove GPS. I don't know if tracking will help him, and state if you will have any objections to tracking only.
I don't have any objection to that.
I'll give him tracking only, but I'm not going to remove the GPS. Yes.
On the bond condition, if I'm somewhere and somebody comes approach me and they tell me she's there and I leave and they cause the problem, I just want to know how I'm at fault. If I'm already somewhere and they follow me or find out where the party at and then I leave and her friend says I did something, how I'm at fault? I don't.
All right, it sounds to me like you're trying to give me the facts of the case as you see those. This hearing that we're having right now is not for me to determine the facts of your case and whether or not something happened or did not happen. Unless you want to do a bench trial, then of course I will hear everything. All right. All right, so really his plea deadline date is scheduled for March 18th, but we do have a murder trial that's up first. So if something happens to the murder trial and he wants his speedy trial, we'll give you a trial today. So if y'all still want a jury trial today, we will give that to you. Otherwise, your plea deadline date is March 18th.
Do you want to have the plea deadline date as March 18th, or do you want to be on call for today, Mr. Evans?
It's up to you. Otherwise, you're due back here on March 18th. So we potentially could give you a jury trial today, or either you can come back on March 18th. Which do you prefer, Mr. Evans?
March 18th.
I'm sorry?
March 18th.
All right. So do you still want to assert your right to a speedy trial, counsel? Because your client is saying that he prefers to come back on March 18th.
I'll defer to my client. Your Honor.
All right. Are you withdrawing your motion for a speedy trial?
This time, Judge, we would ask for the trial date of March 18th.
Well, March 18th will be your plea deadline date. All right.
We would be
So,
ready for trial on that date as well.
all right. So are you withdrawing your motion for a speedy trial?
Yes.
All right. Is there anything else? All right. We'll see you back on March 18th.
Thank you, Your Honor.
You're welcome.
Thank you.
You're on that, sir?
Yes.
Oh, exactly.
Thank you. Could I see the file on Ayala, please? All right, just give me a moment. I think you gave me the file on Ayala. Thank you. Greg Wright. Greg Wright. All right, Karen Garnica.
Morning, Ron.
Good morning. All right, this is a motion to increase bond that's been filed by the state. We're going to go on the record. Court is calling NIMAG number 708742, State of Texas versus Karen Garnica. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Johnny Rodriguez, somebody's got to be here.
And are you Ms. Garnica?
Yes.
All right, the state has filed a motion to increase your bond. Defense, have you had a chance to review the motion?
I am, Your Honor.
And are you ready to proceed?
Yes, Your Honor.
All right, state, do you have any witnesses?
We don't have any witnesses, Judge. I just have argument from, based on the violation reports. This is the fourth violation report, Judge, and on the first page of my motion, there was a violation report.
Just one moment. Could you pull the violation report on Karen Garnica for me, please?
I have it, Judge.
Thank you. All right, state.
So Your Honor, what we're asking for is for the bond to be raised to $100,000 with full house arrest GPS. The reason we're asking for that is this is the fourth violation report, Judge. On the first violation report, which was filed May 17th of 2023, the defendant was continued on ignition interlock. Just a little less than half a month later, on the 30th of May, there was a second violation report where the bond was increased from, I believe it was $35,000 to $50,000 and continued on ignition interlock. And then a month later, in June of 2023, there was a third violation report. The defendant was supposed to continue with no driving, in-home breathalyzer, and add drug and alcohol testing random. This is the fourth violation report, Judge, and so the reason for this violation report is non-compliance with the random drug and alcohol testing with diluted samples. So it appears to the state that the defendant is not complying with the conditions of her bonds. We're asking that her bond be raised. We're asking for the addition of the full house arrest GPS, Your Honor. This is, the code says you can set reasonable conditions of bonds to protect the community, and so that's what we're asking for, Judge.
All right. Any objections to the court reviewing the violation reports, counsel?
No, Your Honor.
All right. So the court will note the first violation report. She was continued. That was signed by Judge Nahara, and that was on May 18th, 2023. And that violation report was due to the failure to enroll ignition interlock. Then the second violation report, which was signed by Judge Nahara, there was a bond increase of $50,000, and the issue was failure to enroll in ignition interlock. Then the third violation report was signed by Judge Nahara, and that was from June 22nd, 2023. And the issue was high BRAC readings. And so that was to continue with no driving, in-home breathalyzer, and drug and alcohol testing. And now we're here on the fourth violation report, and the issue is non-compliance with testing. All right, counsel.
Yes, Your Honor. May I ask her? Yes, what is?
Sure. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you keep your voice up. State your name for the record.
Karen Garnica.
All right.
Mr. Nika, you heard the first violation about the issue. Can you tell us what was happening at that time?
I do not have a vehicle to install the interlock
And how was that?
because I have just crashed my truck.
And my understanding is that you had another vehicle under your name?
Yes, I did a favor to a friend and I took out a car under my name, but he's the one paying all the bills.
So he paid the bills, insurance and all that, and all that
Yes.
stuff?
I'm
So-
sorry, you're gonna have to speak up and slow down. I can't understand your questions,
I'm
counsel.
saying that. So you don't drive that vehicle as well?
No,
So you haven't driven any vehicle since then, correct?
no.
And can you tell us what was happening at the time where the bond were raised to 50,000? When we went to the judge, and the bonds were raised to 50,000.
The second violation was also because I do not have a car and I couldn't install the internet.
And did you fix that?
Yes,
How did you fix it?
we gave me a portable breathalyzer
And when did they when did they give you the portable breathalyzer?
on June 10th.
And have you had any issues with that since then?
At the beginning, because I had never used one, so I didn't know certain foods and drinks will make it a false positive.
I'm sorry, what?
Because I didn't have experience with the breathalyzer, so I didn't know that certain foods and drinks would cause a false positive.
And what foods, drinks were you taking at the time?
The very first time I had eat a grilled cheese sandwich, and apparently the cheese and hot bread will cause a false positive.
And were you also drinking energy drinks such as Ghost and Powerade and?
Yes, I drank pre-workout.
And have you been drinking those drinks since then?
No,
And regarding the last violation of two diluted sample, what did they tell you about that?
that I drank too much water before taking the test, so it came out too diluted, and it was suspicious.
Okay, and when did they tell you that?
February, and it was the very first time also I had taken the urine.
And when did you do that?
No, she didn't hear what you said.
Okay, when did you take those drinks?
No. What you just said, repeat it.
Oh, the very first time when I took the UA, they told me I have drank too much water. On the 9th also, I believe it was 3 times.
Okay, and were there any consequences because of that?
No.
Did you have to come more
Oh,
than one
yes,
time?
I'm sorry, yes.
Did you have to come more than one time to San Antonio to be tested?
Yes, I'm testing weekly now,
Okay, when did that start?
on the 9th,
Okay, and are you currently working right now?
yes.
And where do you work at?
Marmoli Granito Nido,
How long have you worked in?
almost 4 years.
And what do you do with the money so you earn from your?
I help out with the rent and the bills at home,
How much do you pay per rent, for the rent yourself?
625,
And for the waters and utilities and electric, how much do you?
around like 150.
And what are you asking the court to do today?
To please, keep things how we have them.
Why?
Because if I get in house arrest, I might lose my job and I won't be able to help out my parents with the rent.
Okay, and you haven't engaged in any criminal activity since then? Since you heard, Judge?
Oh, any questions?
Yes, ma'am. I'm Ms. Garnica. My name is Hank Wilkins. I'm one of the prosecutors here. If I ask anything that you don't understand, just let me know and I'll rephrase it. So where do you work?
Marmoli Granito Nido.
Is that, what is that?
MA, it's, we sell granite for the countertops at home.
You sell granite?
Yes, marble quartzites, like for home.
Okay. So what is the name of it?
Marmol, MARMOLYGRANITO.
Okay, okay, all right. And so you're saying your testimony to the court is that the false positives were due to a grilled cheese sandwich, energy drinks, and too much water.
Yes.
Okay, I pass the witness, Judge.
All right, any other questions?
Judge, so we have no more questions for the witness.
All right, the court will hear argument. State.
Your Honor, this is the 4th violation report. We believe this bond increase in the GPS full house arrest is necessary to protect the public with the alleged offense is intoxication assault. These violations reports, I believe, show a continued behavior and also escalating behavior. And I don't find it particularly credible that grilled cheese sandwiches, energy drinks, and too much water caused all 4 of these violations, Your Honor. So that's why we're asking for the increase in the bond amount and the full house arrest GPS, Your Honor.
Your Honor, I would ask for the court to consider what the Ms. Garnica said. She said she didn't know. She ate a grilled sandwich, but most important, she said that she was drinking power drinks and energetic drinks as well. And those contain a derivative of alcohol. She stopped drinking those things. And concerning the interlocks, she had a portable device. She would finally issue one. She hasn't engaged in any criminal activity whatsoever. She has tried to remain as compliant as possible. I understand. I don't think this is the case where it's warranted to go with the orders what the state's asking. I will ask the court to keep it the same. I don't want her to lose her job. Her family depends on the job, and she's already going weekly, coming weekly to San Antonio for the testing. I think that should be enough. That's all I have.
All right, so state, wouldn't this be solved, the issues be solved with full house arrest?
Sure, Your Honor. Yep, that would work for me.
All right, what I'm seeing before me, counsel, is continued violations.
Judge, if I may.
Yes.
On the first 2, Your Honor, there was a hearing, I believe with Judge Najera, but there was an issue with the portable device. Went back and forth trying to get the bond. I don't think that those should be held against her. And the latest ones, power drinks, stuff like that, she did admit that she didn't know about it, but now she knows about it. So I want to ask for the court just to keep it the same, Your Honor. If she needs to come twice, 3 times a month, I think she's already coming once. I think that in itself it's a sanction. I would pay for her to lose her job, Your Honor.
All right, I'm gonna put her on full house arrest. I'm not gonna increase the bond. Is there anything else?
That's all I have, Your Honor.
All right, thank you.
You're welcome. Have any discuss?
Yes.
Thank you.
Just 1 second. I call you up in the order in which I received your file, so you need to have them pull the file. Greg Wright. Is the attorney here for Greg Wright? Gabriella Rubin Chuck.
We're here, Judge.
All right, where is she?
She's outside with her boyfriend.
Oh, she needs to come in here.
Okay, I was actually just gonna ask you about her. Yeah, she was in the first row. I mean, she's been here. So, I'm gonna lose my place in line by going to get her.
Go get her. Tell her court is in here and she was late for court this morning.
Now approach.
Your possession.
Once they pull the file,
There is no file.
all right, then she'll just give her your paperwork and I'll take you in the order in which you'll appear. All right, everyone just have a seat. I'm gonna call y'all in the order in which you appear. People never listen to the morning instructions.
I'll be back shortly. I'm supposed to be in the one.
All right, where's your client, counsel?
Great.
No, I'm talking to counsel, Bob Behrens.
Judge, she's in the restroom, her boyfriend's going to try to rustle her up.
All right. Who's here on Ernest Gonzalez? All right, why were you late for court?
He was,
No, why were you late for court?
I'm sorry, ma'am, I have two different court rooms that I had to appear in today.
All right, so let me explain something to you.
Yes, ma'am.
Those courts are, you don't need to bend to the
Oh, I'm sorry,
microphone. All right, those cases are in what court?
County Court 1,
County court at law, right?
number 1.
You know what takes precedent over county courts? District court.
I wasn't aware.
Well, let me just explain it to you. So next time you need to be here first. Do you understand? All right, so where are we on this case?
He was served with the indictment.
So have you talked to the state?
I did confer, and we would like to have an opportunity to get the balance of the discovery.
Where are you on discovery?
I think everything should have been uploaded, Judge. We just, I think he wants to show the evidence to his client and discuss the offer with him.
All right, so have you tendered an offer?
Yes, Your Honor.
Let me see here. All right, we're going to come back on March 18th. And March 18th will be your plea deadline date. Once I give you a reset form and you sign it, you are excused. All right, once you sign that, you're excused.
Ernest Gonzalez.
Gabriella Rubinchuk.
We'll look forward to return to the restroom, Judge.
All right. Everyone, a jury is coming up here at 11, so move with a purpose.
Yeah, I'll be right back.
Michael Alvarez. All right, just have a seat.
Bottom 2.
Jordan Robbins.
Good morning, Your Honor.
Good morning. How's it going?
Good, how are you?
Oh, I can't complain. It's another day.
Right? So my mom says we're vertical and ventilating, right?
Yes.
Oh, standing and breathing.
All right. So we're set. Let me see what this is set for.
It's a discovery. We're supposed to turn over medical records by today, Judge.
Yes.
And we received them. Marina and I discovered them in Marina's inbox late in the day on Friday when we were
Yes.
here for trial. They were put on our paralegal stuff this morning to be uploaded.
Okay. So anything other than those medical records that are left?
I don't believe so.
No.
All right. So what we're going to do is we're going to come back on March 11th, and that's just to make sure all the medical records are uploaded. Then you're all going to get your jury trial date.
Okay,
All right. So once you sign the reset form, you are excused.
and Judge, is that gonna be our plea deadline date as well?
Yes.
Okay,
And of course, if you don't have the medical records, please come in sooner and let me
Yes.
know that
Yes,
something
ma'am.
happened with the upload. And is this something that she'll need a separate just for to get it, or?
I'm not entirely sure. We sent it to our paralegal to upload. If it's too voluminous, and we'll make a copy for her,
or I can bring over.
an external or something. Yeah.
I think it'd probably be best to
Yeah.
bring that over.
Okay.
All right, once you sign the reset form, you are excused.
Thank you, Your Honor.
Thank you.
You can check it out, Judge.
All right, just give me a moment. All right, Ruby, a check. All right, why were you late for court?
Honestly, I was not notified that I had court. The only way that I found out was.
I'm sorry, what?
The only
Everyone,
way-
please whisper.
The way that I found out that I had court was because I actually looked myself up on Central Records. And I saw that today I had court. So I was unaware. Nobody told me I had court this morning.
All right, so usually those are in the system, but you're gonna get a court date today and it's gonna be written down, so you'll need to be here on time. Do you understand?
Yes, yeah.
Where are we with discovery?
My understanding is that Mr. Barron's talked to Jason, is that I'm not aware of any discovery issues.
All right, any discovery issues?
Not that I'm aware of, Judge, and Ms. Rubencheck had expressed an interest in hiring an attorney, so we said we'll give her time to investigate. that.
All right, was an attorney, was an offer tendered?
Yeah, he's,
Okay.
where'd he go?
I think he stepped out momentarily.
Oh, no, you're an officer of the court. I take you at your word. So an offer was tendered?
He was making me an offer as we speak.
But I think Jason had to step out. I can make an offer, Judge.
Okay, so if you'll make an offer, and then I'm gonna set this for a plea deadline date of March 18th. And if you have an attorney that you're gonna hire, that person will need to be here on March 18th. Do you understand?
Yes, sir.
And do not leave the courtroom before you receive your offer. And I'll give you your reset form.
I'm gonna put it right now.
John. Do you have the client? Let me see. Alexandria Alvarez? All right, so that's coming back on March 18th, if you can be here. They say that the lab tests are in.
Okay.
And so I recalled it for March 18th. Caleb Crum. Where's the attorney for Caleb Crum?
How are you today, Judge?
Oh, I'm doing great. All right, so there's supposed to be an update on mental health.
So Judge, he's been waiting for the competency to be done, but hasn't got anything there. And I do have an update on the private one that you've granted funds for.
Yes.
I'm struggling to get that same expert paid on a different case that I had her appointed on, to the point where she is now saying that she is not inclined to take any further.
All right, so
appointments.
that's not out of this court where she's not being paid, is it?
No, absolutely.
Okay.
Yeah. And for what it's worth, the judges in that court have been helpful. It's just been a process to get everything signed, and then I suspect she's going to be paid eventually, but I understand her frustrations.
Mhm.
And so what I'm hoping is you'll give me a little bit of time to see if I can find a different expert. I do think the expert's still needed. Obviously, the court agreed in granting me $1,200 for it. And then if you'll allow me, I'll just run down to competency this morning and talk to Judge Carruthers staff to see
Yes,
what we're
if
missing
you, I
there.
tell you what, if you will run down to Judge Carruthers Court right now
Okay.
and then come back up and see what date they give you, that will be appreciated.
Absolutely. I'll be right back. I'll let them know when I'm ready.
All right, thank
Appreciate
you.
it. Thanks, Judge.
You're welcome.
Yeah. I think it's.
Who's here on Greg Wright? The attorney for Greg Eldridge Wright? So as you can see, a lot of this, there are a lot of moving pieces. Okay, so this is what you're going to discover. Do you know, usually on this side, it's very civil. Usually on the civil side, it's not as civil because you're dealing with money. So that's what I've discovered. There are some nice attorneys on the civil side, so don't get me wrong. But for example, on this side, let's say somebody didn't file a certain motion on time. Usually people are like, okay, you can go ahead and file it. But usually on the civil side, it's no. So, Renee Gardia. Yes. Okay, so where are we with that?
Judge, Renee, after that ED, she switched over to Center for Healthcare Services. They're monitoring her now. I talked to Michelle Star Salazar, the program director, last week, and they're still in the screening process.
Okay.
Renee has an appointment on the 22nd with Center again, and so hopefully.
Okay, that's the 27th of February,
22nd.
22nd of February.
I think 2 or 3 weeks, we may know whether she's going to be in or not.
All right, so what I'll do is I'll recall this for March 18th. That should give everybody enough time. And once you sign the reset form, you are excused.
Thank you, Judge.
You're welcome. Thank you, Jason.
Yes. Good files.
All right, who's here on Jasmine Hardaway?
Present.
All right, let me
Mr.
see.
Shumway's also here. Ms. Hardaway's here.
Ms. Hardaway, come forward. All right, why were you late for court?
I was outside sleeping in my car. I worked this 12-hour shift. I set an alarm for 10 minutes before, which is my GPS. Then when I woke up, I didn't realize the alarm was wrapped around the building.
All right, so here's the thing, you can't be late for court, you understand?
Yes, ma'am.
Okay. All right, we have a murder trial that's actually scheduled at 11, so this is not going to go because the murder trial is going to go. So if for some reason the murder trial ends up pleading, then I will call you all back, but otherwise, I'm going to give you all a different jury trial date.
And Judge, just I really shared this with Mr. Shaughnessy, just some light. I believe last time we were told the court that we would be possibly re-indicting this case.
Okay.
And I've had to talk to administration of the DA's office. We will be re-indicting the manslaughter. That will be done probably this week, if not by next week. I've talked to Mr. Shaughnessy about it. We'll probably do it under the same JN so that another arrest warrant won't go out.
Okay.
But the other case can be set for trial at any, it's a separate case, the assault on public servant, I believe.
All right, and on that case, do you have the transcripts?
I have a transcript of the prior trial, yes.
Okay. All right, so I'm trying to figure out, so you're thinking this will be indicted next week?
I've spoken to Laura Metzel about it, Judge. I just haven't had the opportunity to go in depth about it. I believe it will be, but I'm going to try to do it this week.
All right, so is everybody okay with setting this then for March 18th? To make sure that everything has been re-indicted and then give you your jury trial date on that date, counsel?
Sure. I don't know that Mr. Garrahan will be in very good shape on March 18th.
Oh, what's going on?
I will be
It's the
fine.
morning after St. Patrick's Day.
I thought he was referring to the fact that it's my daughter's birthday.
Yeah.
But it is
Two
St. Patrick's
separate and
Day.
distinct reasons.
All right.
They may, as two Irishmen here, they may join in the continuance on that day.
Okay, well, we'll see how you all come in.
I think it'll be fine.
Okay, so then March 18th will be the date for you all to actually get your jury trial date?
Well, Your Honor, that if it's re-indicted, it might be a situation where the defense will be filing more motions under.
Yes. That's why I'm saying March 18th.
Okay.
And so that will just be a date for you all to come in and get your jury trial date. So that won't be a date that you go to jury trial, you understand?
Yeah, I've been waiting. You told me in December, remember that for this other case, that would be the last.
Well, here's the thing. The state is re-indicting your case. Now, if y'all want to do a quick jury trial on the assault public servant, we can do a quick jury trial on assault servant. I think that y'all probably want to do the manslaughter case first.
That
Judge,
would appear to be
we're fine either
more
way, Judge.
normal course of action, Your Honor.
All right. So your attorney wants to go on the manslaughter first. And the state is re-indicting the manslaughter case. And then your counsel is telling the court that they're going to file some motions in regard to that re-indictment. I have an idea what those motions will be. Of course, I don't like to make assumptions, but I have an idea what it will be. So I think, well, I'm not even going to say this. You can listen to your attorney's advice or not. That's completely up to you. But your attorney is telling me, recalling this for March 18th, they're in agreement with that. And on that date, you will be given your jury trial date.
Okay.
And what I can tell you about case settings in this court, we're in trial every week. The prosecutors will tell you we're in trial every week. So there are some cases that are older than yours. For example, we're going on a murder case. That person is in custody. So that case is taking precedent of yours. You understand?
Yes.
All right. So I'm going to give you a reset form for March 18th, and we will give you your jury trial date after that date.
Both cause numbers on that form, Your Honor.
Yes, I will put both cause numbers on that.
Will do. Great. Grab a seat for your signature.
You ready?
Joshua Patillo. Mr. Patillo, if you'll come down. All right, so on Mr. Patillo, you've received the report?
received.
All right, so we will give it to you. Just one moment. If you'll have a seat, we're going to get that for you right now.
Okay, thank you, Judge.
You're welcome. I do not know what is going on with Outlook today.
You still have the Chrome file, Fish?
Just give me
Sorry,
one
okay.
moment. For some reason, my Outlook is just always missing.
I'm glad you
No, that's only that one.
All right, what's the issue on Chrome?
Judge, they said it takes about 2 months to get it scheduled. It was sent over, I think, middle of January and ballpark of January 15th. So I think that gives us until March 15th, where hopefully, they couldn't give me a date. I asked that.
All right, can I see the file on Chrome?
You want my client back up, Judge?
Yes.
Okay.
Oh, I'm so sorry. I have it here.
Okay,
I have so many files up here today.
I'll take whatever back you need.
All right, so we're going to recall your case on March 18th.
Yes.
And they think that they will have that done by then, counsel?
It was unclear if it would be scheduled by then or if it would be done by then. I took it to mean it would be done by then.
Okay.
If we get closer to that date and I don't have, if he hasn't had the evaluation with one of the doctors yet, then I'll come let the court know ahead of time. I just got back in the country. I would have let y'all know before today.
Okay.
You said which day, Judge?
March 18th.
Thank you. I will use my best efforts to locate a substitute expert witness, and then I will bring you an updated order with that name, should I get someone before then.
Okay.
Would that be okay with the court?
Yes. All right, once you sign the reset form, you're excused. You're welcome. Miguel Santiago Colon.
I'm present, Your Honor.
Yes.
He's not present here today. This is a motion for the pretrial services file. We have a hearing set on the 22nd in front of Judge Nahara, a speedy trial hearing, and we're hoping to get those records to be used at that hearing.
All right. So you'll need to set this for a hearing because I don't know anything about it. I see what you're writing in here specifically that you're requesting, but the pretrial services officer will need to be in here. So we're going to send it down to Judge Nahara.
Okay.
Okay.
We're already set on the 22nd. Would it please the court if I just ask for if the pretrial services officer is available to try to do it on that day, or just coordinate with that
Well,
court?
no, because if you're going to have the pretrial services officer here, then you all still are going to be asking for records on that date, right? Or are you just going to depend on the officer's testimony?
I think we need to cross that bridge when we get there, but
Sometimes bridges need to be crossed before they're built. This seems like one that you need to cross, maybe swim through the water. So we're going to send it to Judge Nahara so he can hear that. And that can be
Yes,
done
Judge.
today.
Oh, okay.
All right.
I misunderstood that.
Yeah, no, no,
All
no.
I was asking is if we could hear it that day. I'm sorry.
Yes, no. So that's going to be heard today, that motion.
Okay.
So you can have the records for your hearing.
Thank you, Judge. I appreciate it.
All right, thank you. Adrian Del Terrio. Who's the attorney? All right, your client, which we knew was not going to be approved for mental health court. So what is happening with this case?
Judge, we got a new offer today, but that's still not, we're still not in agreement. So whatever our next step in the process is.
All right, so new offer was tendered today.
Yes.
All right, on this case, I'm going to recall it back on March 4th. March 4th is going to be your plea deadline date. Is that enough time for you to consider the offer?
Should be, Your Honor.
All
I'm
right.
waiting.
So we're going to come back on March 4th for our plea deadline date. All right, thank you. Yes. Oh, yeah, I'm gonna make it. Yes.
No, I don't need one.
Yes, no setting needed.
Okay, that just is the package.
Philip Diller. All right.
Morning, Your Honor.
Morning. So we're having a jury brought up. We'll see where we are.
Oh, okay.
Yes.
Do you expect that to happen this afternoon or?
Today, we shall
Okay.
see. All right.
Oh, okay. I thought there was a murder case.
Oh, there is, but you never know. Sometimes
Sure.
things fall through.
No, you're right.
All right. Okay, thank you.
Then what, you want us to hang around?
Yes, hang around.
If we're gonna have a trial, I need to go back to my office and get my
Okay.
briefcase.
All right. We will definitely give you a chance to do that.
Okay.
All right. Thank you.
Thank you, Judge.
And can you check to see, I know there was a sanity evaluation that was emailed to the court on Joshua Patillo. Can you see if you have that? Sure, it is 2020 CR 9880.
It shows here that the attorney got notice for a signing on March the 7th.
No, I just need a copy of the evaluation. Thank you. But yeah, so usually this is how it is every day. Mhm. Yes, it's going to be called for another day. And because we can only do one jury trial at a time, of course, the other things that are set for trial are going to end up being moved to a different trial date. And I know sometimes people are frustrated because they want their trial and they want it now. But what ends up happening is you can only do one trial at a time. I mean, they can always ask. But normally when the trial has already started, the trial has started and there's no going back. But I haven't been involved in cases before where people entered a plea during the trial, so it's possible. Okay. Gregory Oliver. Is he outside talking to his attorney? Jesse Garcia. All right, so Mr. Garcia, we're gonna take the murder trial up first and then we'll do the other things. Okay.
Other case meeting.
Trial cases. Just give me a moment. Ms. Compton. On your case, the murder case, Angel Gonzalez, y'all are still prepared to go on that?
Yes, Your Honor.
Okay.
Yeah.
All right, so that's going to be the first case. And then everyone else who's up for trial, I'm going to ask you all to come back at 2. And at that time, if you have a client who's in custody, you'll be given your new trial date. All right, does everyone understand? So Gregory Oliver, I think his attorney was here to speak with him. Raymond Alejandra. All right, I'm going to ask you all to come back at 2. Philip Diller, come back at 2 p.m. Who's here on, oh, Jesse Garcia, that'll be at 2. Meredith Chacon, where are we on Mr. Heflin?
What? Like what?
All right, so we'll take that plea up.
Thank you so much.
Daniel Hernandez.
We have to meet it. Yeah, right.
All right, write the plea paperwork and we'll take that up. Andrew Orozco.
We're gonna ask the court for a reset, Judge, on that. They just put the file up there for you.
Okay. Andrew Orozco,
He's in.
come down, please.
Danny.
All right, Mr. Orozco. You are set today, and let me see.
And Judge, there was an Agasol deadly weapon that just got indicted last week.
All right. And are you on that as well?
Yes, sir, I'm on all of this.
Okay. So counsel, sorry, you had a question, you were raising your hand, sir?
Yes, ma'am.
Yes.
And I don't know if you received my letter I gave to you.
No, what ends up happening whenever you send a letter from the jail, what ends up happening is one, it's reviewed by the people at the jail.
Okay.
So everybody needs to be careful what they're putting in letters. And then I don't receive it. The persons who end up receiving it are the state's attorney because they're entitled to look at it. And then once it makes its way into the court's file, that's when I see it. So whenever you send a letter directly from the jail to the court, it doesn't automatically come to me.
Okay.
All right.
And then also I sent a letter to SAPD about the situation.
Okay. All right. So what we're going to do is I'm going to reset this and we're going to reset this for March 18th.
I was gonna ask for 2 weeks, just so the state could potentially talk to their witnesses and maybe we can get a resolution on this matter on the ag assault, if that's okay with the court.
All right. I'll set it for March 18th. Then if you want it sooner than that, you can always have him brought over sooner. And the reason why I'm saying March 18th is because you're in trial this week.
And just so the court's aware, I am starting a juvenile trial in Kendall County on that day, on the 18th.
Ah, well, we can put it for March 11th. Are you okay with March 11th?
That should be fine, Judge.
I start another continuous sex abuse of a child.
All right, we'll put it for March 4th.
That's perfect.
All right, we'll bring you back on March 4th.
I'm just trying to get it resolved, miss.
Well, here's the thing. Let me ask you that. Let me ask you this. Do you want your attorney to try to resolve an issue and they have not seen a case because it's just been indicted? What that means is if the state wanted to be unkind, they could probably say, oh, this is a 20-year case. Your attorney doesn't know if that's the case or not because they haven't received or seen the information. So your attorney is trying to get the information for you so that he can represent you competently. You don't want anyone to give you a decision on something when they haven't seen everything, correct?
Yes, ma'am.
So that's what we're trying to do. And we're trying to do it as quickly as possible. He's trying to do it as quickly as possible. So we're saying March 4th.
Thank you, sir.
All right. You're welcome.
March 4th. Yes, ma'am.
Yes.
Thank you, Judge.
Thank you, sir.
Yeah, just have a seat, sir.
All right. Can I see the file? I think I already have the file on Greg Wright. Where is the attorney, Adam Pultz? And I think he's having a competency evaluation that's done. So Deputy Laura, on that case, can you let Mr. Wright know that we're going to recall him for March 18th?
Yes.
No, they did the report. So the report is done.
Right, but then I'm speaking to her. She said that she hasn't, that it was done on the 24th and they have not, it has not been completed yet.
No, it's completed because I've seen the report in the email. So I don't know why they don't have it up. Just one second.
Yes, ma'am.
On Chia, just one second. Let me get the evaluation. Can you place this on mute just for a moment, please?
Working on the people, Renee.
Kathy. On Patio, I know what has happened now. Because that-
I'm glad somebody.
Yes. So what we're going to do is we're going to recall your client Patio for tomorrow. And between now and then, I will make sure that you get the report.
Okay.
So Deputy Laura, if you can have Mr. Patio on recall for tomorrow.
Yes.
Mr. Patio, we're going to bring you back tomorrow, okay? And I'll have that report for your attorney.
Thank you.
You're welcome. And then if I can see the parties on Heflin. Oh, thank you. You two have a great day. And have some patience. Put some patience in your pocket, okay?
Yes, ma'am. Thank you so much.
You're welcome. All right, court is calling 2023 CR 10633, State of Texas versus Devin Heflin. Could I have parties announced for the record for the state?
Alex Jackson.
Defense?
Or Alexander from Meredith Chacon for Mr. Heflin.
And are you Mr. Heflin?
Yes, ma'am.
Any objection to this attorney standing in for Ms. Chacon? All right, so what is happening, Mr. Heflin, is this is an attorney that works in the same firm as your attorney, Ms. Chacon.
Yes, ma'am.
My understanding is that a plea bargain agreement has been worked out between Ms. Chacon and the state. All right, so Ms. Chacon probably had to go to another court. So this attorney is standing in for her. My understanding is that this attorney is not here to change your plea bargain agreement. He's just here as an attorney standing in for Ms. Chacon so that the plea can be completed. If you would like, we could wait for Ms. Chacon to come back, or either you can go forward with this attorney. Which do you prefer?
You said you work with her? Apart, we're in business together. So you know all her cases though? Yes. She knows mine.
All right, do you want to speak with him?
Yes, ma'am.
All right, if you all will step back and talk to each other. Okay,
Sorry.
all right,
I had to take comments.
no problem. And for the record, for defense?
Meredith Chacon for the defense, Your Honor.
All right. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
All right, Mr. Heflin, I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am. I did understand it.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Going to show you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Heflin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 7 years in the prison and there are no applications. And I see outside the agreement, there's a request for an affirmative finding of family violence. Did you understand if I find that there's family violence and that this is a case of family violence, and I enter an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition? Did you understand?
Oh, yes, ma'am.
And did you understand you would not be allowed to be designated as primary custodial parent? Did you understand?
Yes, ma'am.
All right. And also, if I find that there is a deadly weapon involved, there will be an affirmative finding of deadly weapon. Did you understand?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, ma'am.
State,
Yes, ma'am.
defense.
Yes.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement, the state is requesting no contact with Kaydin, Kaydin Butler and James Butler, affirmative finding of deadly weapon and affirmative finding of family violence. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Stand up for State Exhibit 1 with all attachments.
And Your Honor, we have no objection. I have gone over the attachments with my client.
All right, I'm showing you the waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Also, I forgot to ask, are y'all proceeding on both counts?
Yes, Your Honor.
Yes.
And are you pleading no contest to count 1 and count 2?
Yes, ma'am.
Okay. And are these counts to run concurrent?
Yes.
The court, no problem. The court will review states exhibits 1 and attachments for sufficiency. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client was on a parole that had been transferred here to Bear County and would like you to give him credit for that time to run concurrent as well. The state had no objection, is my understanding.
No, Your Honor.
All right, and which, do you have a cause number or anything?
You might.
And the court will find you guilty of count 1, guilty of count 2.
And for the record, Your Honor, the victims are also aware of this, Your Honor, and in agreement with this. And I do have the case number whenever the court is ready.
Okay. Count 1 and count 2 will run concurrent. And then what is the cause number for parole?
19 CR S 238347. It's out of North Carolina.
All right, and the court will give you credit for any time served in that cause number and credit for any time served, of course, in this case. There's an affirmative finding of deadly weapon, affirmative finding of family violence. There's to be no contact with Kaydin Butler and James Butler. And I'll sentence you to 7 years in the prison. Is there anything else with regards to sentencing from either side?
Not in the state, Your Honor.
No, Your Honor.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea, because I followed your plea, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed, and also a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. How old are you?
20. I just turned 21 2 days ago.
All right, so I don't know what was going on with you at the household or what's going on with you in your life. If there's a mental health issue or anger issues, that's something that you're going to have to work on. Otherwise, you may find yourself living in a prison. You understand? And when you get to the point in Texas where they stamp you as a habitual, that means in some cases your minimum sentence is 25 years. You understand? All right, do better, okay? All right, good luck to you.
Appreciate it.
All right, who's here on Jack Bernal? Court is calling 2023 CR 9749, State of Texas versus Jack Bernal. Counsel, you're on this side. Could I have parties announced for the record for the state? For the defense?
Paul Acevedo for the defense.
And are you Mr. Bernal?
Yes, ma'am.
Counsel, have you received all the discovery and did you review that with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application? Yes, there is. I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Showing you what's entitled True Bill of Indictment. Just one moment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
We're gonna waive count one, Your Honor, proceed on count two.
We have no objection.
All right, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in that count, you're charged with possession of a controlled substance, penalty group 2, 4 grams to 400 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Thank you. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I feel he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I feel he is, Your Honor. Now.
Mr. Bernal, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, state is proceeding on count 2. There's a $1,000 fine. State recommends deferred adjudication. This is run concurrent with County Court Cause number 708-414. They're taking in consideration 2023 CR 9748. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
That is.
State?
Yes, Your Honor.
I had struck this weekend, so.
No problem.
That is the agreement as we understand it, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. State is requesting that your deferred adjudication be for a term of 6 years. There be a TAP evaluation, 120 hours of community service restitution, and the DOEP course. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 2 in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Your Honor, I offer State's Exhibit 1 in the attachments.
No objection.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything that you wish to say on behalf of your client?
Your Honor, he has accepted responsibility for his behavior. He's taken a turn for the better. He does have his family support. His dad has made it to every court setting. He was here this morning. However, he had his own appointment that he had to go attend to at 11 o'clock. So he's not here, but he does have a support system. He's working and he's doing things he's supposed to be doing right now.
All right. Are you employed?
Yes, Your Honor.
What do you do?
I work at a Dairy Queen, so fast food.
Okay. And do you have any children?
No, ma'am.
All right. And if you're drug tested today, what are the results going to be?
They're gonna be negative. I've been clean for quite a while now. So.
Okay. And do you have your driver's license now?
I have my driver's license on me, but I do have a valid driver's license.
Okay. There's to be no driving without a license. You understand?
Yes, ma'am.
Okay. And thank you for not having any children right now because you got to work on yourself.
Exactly.
So how far did you go in school?
I completed my diploma.
All right. So what are you planning on doing with the rest of your life? What's your dream job?
I like to make music, so probably do the music career.
All right. So, while you're waiting to your music career to go off, you need to be doing something else. So
Yes,
if
ma'am.
music were not to work out for you, what's your plan?
I like business, probably try to open up my own business.
What type of business?
Yes, maybe anything with music.
All right. Because you got to have a plan A, B, and C. You understand? All right, this is what the court is going to do. The court is going to sentence you to 5 years deferred adjudication. There's $1,000 fine that will be probated. This will run concurrent with County Court Cause number 708414.
Judge, on that matter, it's my understanding that the DA's office was going to recommend a time served on that matter. Judgment satisfied.
All right, so it'll run concurrent. So with whatever that agreement is, take in consideration 2023 CR 9748, 120 hours of community service restitution. You can either do those hours, or if you are in some type of trade school, get your business certificate so you'll know how to run a business, or higher level education. The court will deem the 120 hours satisfied. There's to be the DOEP course, regular reporting by Zoom or in person, regular UAs, proof of employment, within 30 days. There's to be no employment as a home health care provider or with minors. Field visits, 1 time per month for 2 months. Then at probation's discretion. And we'll do a TAP evaluation out of custody. And I'm going to want 60 sober meetings in 60 days. And probation, if he's testing negative, we'll hold off on TAP recommendations. But if he tests positive, then we'll start with intensive outpatient treatment. All right. Is there anything else he needs probation? Yes.
Judge, there is one matter. He was due to go to work today at 1 o'clock. However, his misdemeanor case is set at 1:30. So after today, he may have problems with his employment as far as he.
Oh, why don't y'all work that out so he can go do his employment?
I tried to search.
Okay. All right, I'm sure if you talk to the state, they'll let him get to his employment.
I'm gonna email the prosecutors in County Court 12 to JSAT there. If you could just take.
But we still have to enter a plea, unless we can enter a plea here.
No, I can't take it here. All right. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? Did you sign it?
Yes, Your Honor, I did.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do.
All right, we can go off the record. You're going to have to start making better choices. And if there's ever an issue, you can talk to probation about it. If you feel like they're not addressing it, you can come back here. All right. And it's been a long time since I've had one of the ice creams with the chocolate on top. I may have to stop by Dairy Queen to get that. All right, have a good one.
Come anytime.
Judge,
All right, I will.
Judge, you need to start treating yourself a whole lot better if it's been a while since you've had.
I know, right? All right, Daniel Hernandez. Court is calling 2023 CR 10712, State of Texas versus Daniel Hernandez. Could I have the parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Warren Wolf for Mr. Hernandez.
Are you Mr. Hernandez?
Yes, ma'am.
Okay. Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are good.
Going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of assault on a peace officer or judge bodily injury? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your
Did you understand by entering this plea, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty, sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, there's a $500 fine. State recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, I am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is recommending that your deferred adjudication be for a term of 5 years. There be 100 hours of community service restitution and mixed supervision. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State officer, States exhibit 1 and all happens.
Okay. All right, and you've spoken to the complainant?
Judge, we tried to. We were funny.
All right. Mr. Hernandez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I asked Mr. Hernandez to fill out the data sheet for probation, in anticipation that you would grant him that. And let me give you that. So I think that'll answer some of your questions about work and where he's living. He is currently being seen by mental aspects. He's getting mental health.
So here's my question, and I apologize for interrupting, but I want to get to the crux of the issue. The crux of the issue for the court is he's living with his mother, and then his mother calls because he's upset about something. He starts breaking items. I know there may be some mental health issues involved, but is he still living with his mother?
Yeah. I don't have.
All
There's
right.
been no other issues since.
Does she want him there?
Yes, she's allowed.
Well, I mean, sometimes moms allow people, their children to stay. They don't really want them there, but it's sort of, it's my child.
She wants him there.
Yeah.
That's my understanding.
As far as I understand, she's completely okay with it.
All right, state, on this case, have you all had a chance to speak with his mom? Okay. All right, are you employed?
Yes, I just got a job offer.
What do you do?
I do IT work as a help desk technician.
At that job, Judge, there's drug screening for all drugs, marijuana, cocaine, methamphetamine.
So if you drug tested today, what are the results going to be?
Nothing.
And are you on any type of medication?
Yes.
What are you on?
Wellbutrin, trazodone, lisinopril. I'd have to look up the other two.
And have you been diagnosed?
From what I understand, it is bipolar 1 and manic depression.
Okay. All right. Do you have any children?
Yes, 4.
Adult.
And who are they living with? Or are they?
They're adults.
Okay.
And 3 grandchildren.
All right. This is what the court is going to do.
Judge, there's one more thing I wanted to throw in before you make your ruling. He's got several jobs that are out there. One of them is in Comal County in New Braunfels, and asked that he be permitted to travel up to New Braunfels.
All right. This is what the court is going to do. There's going to be a $500 fine that will be probated, 5 years deferred adjudication, 100 hours community service restitution. If you could complete a MIC evaluation, there should be proof of employment within 30 days. There should be no employment as a home health care provider or with minors. Regular reporting by Zoom or in person. Do you have a case manager?
What do you mean for mental health?
Yes.
Yes, I do. I have Dr. Licorice.
Dr. who?
Licorice with mental health aspects.
He's to continue treatment with Dr. Licorice.
It's spelled with an ISH. I just looked it up on the internet. Here's the website.
All right, how do you spell your doctor's last name? Just let probation know the correct spelling, okay?
Okay.
So you're to continue treatment with Dr. Licorice. And what facility do you go to?
It's called Mental Aspects, but she helps me online through Zoom.
All right, with mental aspects. And you're gonna have to file or sign a release form so that probation can have access to that. Do you understand?
Yes.
There is to be field visits one time per month until placement with Mick. He's allowed to travel for work.
Thank you.
You're welcome. And there's to be regular UAs.
Could that be satisfied with his work?
No, because I don't know what their testing schedule is. So there'll be regular UAs and anger management course. Is there anything else he needs probation? Is there anything else you need from the court to be successful?
Judge, on the issue of community services, there are other ways. His schedule between going to probate, to his classes and work might pose a problem. Is there other ways for him to accomplish the community service?
No, I mean, you're gonna have to do the community service. If there's an issue with community service, just let probation know. Do you understand? All right, this is a second degree felony. What are the court costs? All right, will you be able to pay the $325 in installments?
Installments. Yes.
Okay. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
All right, we're going to go off the record. So if there's any issue, let probation know. If you feel like they are not addressing it, you can always come back to the court. Do you understand?
Yes, sir.
All right, good luck to you, okay?
Thank you.
Darius Harris. All right. So where are we on this case?
Your Honor, I'm covering for Mr. Moreno, but my understanding on this case is that we've talked to the state about an offer. You made an offer to us today of deferred adjudication that I'm gonna go over with the client. We'll try to provide some mitigation to the state to consider some other avenues to have this case resolved, including his misdemeanors that are pending as well.
All right, so what I'm going to do is I'm going to recall it for March 18th. And I'm just going to do that as a discovery setting, since this is a first setting, and make sure everybody has everything. And if you all decide to enter a plea on that day, you can. If not, then it's not the plea date anyway.
Okay.
Once I give you the reset form, you are excused.
Thank you, Your Honor.
Kent Wells. All right, if y'all come forward. And on this case, we're going to recall it for the same date for discovery.
Okay, Your Honor.
And I'll give you a reset form. Once he signs that, he's excused.
And Your Honor, just to give background on this case, we've talked to the state. They're trying to reach out to the complaining witness on the case, to talk about the case, and then we'll figure out their next steps from that point on.
All right, thank you.
And Judge, just so the board's aware, we had reached out to the complainant on Friday. He was busy, so we were trying to schedule something for today.
Okay. All right, hopefully I put the right year on those sheets. Oops.
Thank you.